la jueza Otero nos narró un caso, pero yo creo que hay miles de casos en todos nuestros tribunales y ahora nos toca evaluar y reflexionar sobre los procesos actuales. En la tarde de hoy, nuevamente contamos con el recurso del juez Leifman. Nos va a compartir lo que son las reflexiones para un cambio, para lograrlo en Puerto Rico. Vamos a estar hablando de los casos. Vamos a escuchar sus historias, la manera en que podemos modificar y mirar desde una perspectiva distinta cómo son los procesos en las salas de nuestros tribunales. Así que es el momento de aceptar el reto del cambio y de abrir los ojos y poder aportar a esta sociedad. Gracias a todos por prestar atención y vamos entonces a escuchar al juez. Thank you for being here.
Okay, so I get you after dessert. I don't know what's better. Thank you for attending this session. It's been a really phenomenal session today, and I again applaud all of you for the work that you're doing and the work that you're about to do. And figuring out how to harness all this amazing energy and make structural change is always the challenge, but I am confident that it's going to happen. So, when I was 17 years old, I was an intern for a state legislator in Miami. And he received a call from the then editor, actually it was a letter, from the then editor of the Miami Herald about a young man who was in our local state psychiatric hospital. You see, my age directly corresponds to the deinstitutionalization of mental health. So this was 47 years ago, which is hard for me to say that I'm that old. So I'm 17, this is 47 years ago. I'm a little intern. The senator gets this letter, and being the absolute lowest person on the totem pole in the office, I get assigned to go to the state hospital. I grew up in a nice, normal, middle-class family. I had never seen anything bad in my life until that moment, until I walked in the doors of the hospital. The letter was about a young man who was at the hospital. The editor of the Herald was trying to help his mother, who was concerned about his safety and was concerned that he was being abused at the facility. So I walked in through these doors, and it was a scene out of One Flew Over the Cuckoo's Nest. I found the young man. He was in all 4-point restraints. He was probably 100 pounds overweight from the Thorazine that they were injecting him with. He was screaming, he was moaning. It was a scene from a horror show. It was also way before HIPAA. So I asked to see his records. I spoke to his staff, and I was shocked to learn, even as a 17-year-old too, I knew absolutely nothing. And when I say that again, I would never let my 17-year-old go and do this. It turned out that he was not even psychotic, he was autistic. And this is part of the reason we shut down the hospitals. But while I was there, it just turned out that there was a group of advocates at the facility, and they heard that there was a representative from a legislator's office, albeit a 17-year-old who knew nothing and had no power at all. But they insisted that I take a tour of this facility. And they took me downstairs, which I remember quite vividly as if it was yesterday, because this is probably my trauma. And I found these 17 men lying naked in their own feces while a guard stood there with a hose, and he washed them down like animals in a zoo. In fact, all I could think of was that moment is we treat animals in the zoo better than these poor souls were being treated that day. We We were able to get the young man out of the facility, and he ended up living a very good life considering his condition. But it left an indelible mark on me, and 17 years later, I was appointed to the bench. And those same horrors that I had witnessed as a 17-year-old in the state hospital were now going on across the street in my jail because that hospital had been shut down, and there was absolutely no alternative for the individuals that were released from that facility. And I tell you this story because it's part of the history that led us both to the mental health crisis in this country as well as the competency restoration crisis that all of us face. So now I'm going to go back a little and give you a little bit more history, because I think it is so important for us to understand the history, because if we understand how we got to where we are and understand it was not always this way set in stone, we could also understand how to fix it, because this is very fixable. In fact, to me, this may be the easiest of all the fixes in our very dysfunctional criminal justice mental health system. So believe it or not, the early development of civil commitment laws actually began in Greece in the 4th century. Hippocrates actually recognized that mental illness, he called it a natural phenomenon. And he suggested that people with mental disabilities, quote unquote, be confined in a wholesome atmosphere of a comfortable, sanitary, well-lighted place. Not bad for 4th century. The early Romans recognized mental health as well, and they actually established a guardianship program. We're talking hundreds of years ago for guardians to then help individuals that were dealing with these disabilities. And the guardian would actually stay with the individual until and unless there were periods of lucidity. So if the person recovered, which happens, the guardian would leave, and if they got ill again, they would come back. And one thing to know about many of these illnesses, and I'm particularly focused on the psychotic illnesses because those are often the most difficult, and those are often the cases that end up in our criminal system. This is one of the things that we know which makes this such a daunting and complex problem. About 1/3 of individuals that have a psychotic episode only have it once. About 1/3 of individuals that have a psychotic episode have it over a period of time, but it goes away. 1/3 of the individuals have a psychotic episode that becomes chronic and stays with them their entire lives. We don't know how to identify who those thirds are going to be. So we have a tendency to use a one-shoe-fits-all, and it makes it harder. So there are periods of lucidity for people that get these illnesses, and sometimes they may be fine for life. And so we need to work with it and diagnose and treat people for what they're dealing with. English law, beginning in the 13th century, actually developed a fascinating system. And the terms that they used were horrible, but what they did was fascinating and actually pretty darn good. So if you had an intellectual disability in 13th century, 14th century England, they called it idiocy, unfortunately. We don't use those terms anymore. But what they would do is they would take the individual's property. In many cases, they would leave the person on the property. They would use the resources from the property, and when they would take care of the person, the crown, the king, would actually support the individual so that they could have a decent life. They didn't lock them up, they didn't torture them, they didn't confine them, they took care of them. And then when the person passed, they would return the property to the heirs. Now, if you had what they called lunacy, which was a serious mental illness, they would do a similar situation. And they would take the property, they'd leave you on the property if they could, and if you got better, if you had periods of lucidity, they would return the property. And it worked pretty well. Well, Unfortunately, this system that the English had developed to maintain people with these disabilities did not transfer very well to the American colonies. The settlers were more concerned about dying from malaria, Native Americans, and freezing to death in New England than they were about people with mental illnesses. So what did we do? They had no infrastructure. So what we did is we took people with these illnesses and we put them in jail. This is at the very beginning of the U.S. We're talking 1700s. Well, as a result of this, the colonies really created this culture in the U.S. that it's okay to incarcerate people with these disabilities. And this culture actually, in my opinion, still permeates today. And so, from the time our country was founded until the early 1800s, we just incarcerated people with mental illnesses. Didn't matter. So it stays that way until about 1840, when this wonderful, amazing woman by the name of Dorothea Dix, who was a jail reformer, would go around to jails around the United States and see what was going on. And she goes to a jail in Boston in the dead of winter, freezing. She finds these 14 men in the jail, segregated away from the rest of the population. No heat, no clothes, no blankets. They are literally freezing to death. She goes to the jailer and she says, "Excuse me, who are these men and why are you treating them this way?" And he looks at her and says, "Look, lady, they're just a bunch of lunatics. Ironically," he says to her, "they did not commit any crimes, so I'm not getting paid to keep them here. What do you want me to do?" So he's literally killing them. Great. So this one woman, this one person, she's so outraged at what she sees that she adopts a movement that had just begun in Paris called moral treatment. And the idea is we are going to morally treat people with these disabilities. So she goes to the Massachusetts legislature and she convinces them to pass the first Asylum Act. Because what they were doing in Paris is they were taking people from incarceration or people out on the street, and they were building these small 120-bed asylums. And what they realized is people actually started to get better because they weren't being tortured, they weren't being incarcerated, they weren't being re-traumatized, and many people did pretty decent at an asylum. Well, we know how things work sometime in the U.S. We can't help ourselves. We have to be efficient. We have to spend taxpayer dollars really, really well. So what did? We decide we're going to consolidate our 120-bed asylums, and we build these massive state hospitals. Some of them had 5, 10, 15,000 patients. No regulations, no oversight. And these asylums became these houses of horror. And they started experimenting on people in these facilities. I'm sure they meant well, but what they did was horrific. The first treatment for people with these illnesses, believe it or not, was insulin shock therapy because they did some rudimentary testing. They found that many of these individuals had slightly elevated blood sugar levels, and so the geniuses at the time concluded they're all a bunch of diabetics, and if we give them insulin, we'll cure their mental illness. Wrong. So a lot of people got sick, a few probably died, they checked it off the list. I said, you know what though? We're onto something. We can shock people back into sanity. So another genius developed an electric shock therapy machine. I like the therapy part of it. And they would take you in a room, and they would tie you down to a bed, and they'd stick a piece of wood or a stick in your mouth, and they'd put electrodes on your head, and they'd stick the cord into an outlet, and they would shock the living hell out of you. Nobody got better. People got worse, although it's very interesting. Today, with science and research, electric shock does have some value for depression, but not back then, okay? You just can't shock the whole body back into sanity. And so when that failed, some guy who, I say, pretended to be a doctor, invented something called the Friedman pick. And so when electric shock therapy failed, they took you to the same room, they tied you down to the same bed, they took the Friedman pick, and they jammed it behind your eye, and they did a lobotomy. This went on, believe it or not, until the late 1970s. Many of us were alive and well. And so when you see that people, particularly those with mental illnesses that are over 40 years old, are a little reticent to take treatment from us, you can kind of understand why they're a little nervous. The history isn't that great. So, by 1900, every state has a psychiatric hospital. We have all this horrible stuff going on. And in 1950, the first medication is discovered for psychotic illnesses, Thorazine. And unfortunately, it is oversold as a cure. And it has it's kind of amazing that they actually, without computers, MRIs, cell phones, AI, they came up with some pretty interesting stuff, and the chemistry was pretty impressive. But it was no cure, and it had a lot of side effects. But overselling it as a cure got people to start to think that maybe we could release people and put them on Thorazine, and we don't need them all in asylums. Well, in 1963, in his last public bill signing, President Kennedy signs this amazing $3 billion, that's even a lot of money today, $3 billion authorizing act that is going to create this national community mental health system. Well, many people don't know this, but his sister Rose had mental illness issues. I don't know how serious they were, but her father was so outraged about her behavior that he had her lobotomized. And it was a disaster, and it was a butcher act, and she was horribly injured. And so the Kennedys were very sensitive to mental illness, particularly because of Rose. And so President Kennedy signs this amazing act. The idea is that we're going to shut down these houses of horror, we're going to put people on Thorazine, and then we will have this wonderful national community mental health system that will absorb this population. Great idea. Well, tragically, due to the president's assassination and the escalation of the Vietnam War, not one penny of the $3 billion gets appropriated. It was only authorized. Well, at the same time, we start to move into the 1970s. There's kind of this awakening in the states, and there's a lot of attention paid to people with these illnesses and what's happening to them in the hospitals. In fact, some of you may remember, Geraldo Rivera did this huge expose on the state hospital system, and it led to a lot of these reforms. And it led to a lot of lawsuits. And so the seminal case comes out of the great state of Alabama. And it is a fascinating case. And the judges may appreciate this story a little bit more, so I won't go too deep into it, but it is really a fascinating story. So Alabama was using a cigarette tax to fund the state hospital. And the tax was getting cut. Sounds like the old story. Doesn't matter what year it is, right? Got to cut those taxes. Well, the doctors freak out because they think, hey, if this tax gets cut, there's not going to be enough money to run our hospital and we may lose our jobs. So the doctors file the lawsuit against the state and against the guy that ran the hospital. And for the plaintiff, they found this kid, who was a kid, Ricky Wyatt, who was kind of living at the hospital because he had a relative there. He didn't really have mental illness. He was just a juvenile delinquent. But they picked Ricky because he had a relative that worked there as the plaintiff in the case. So lawsuit gets filed, and it ends up in front of one of the most brilliant federal judges in our history, a guy by the name of Frank Johnson. Frank Johnson is the same judge who releases Martin Luther King out of a jail in Alabama. It is really worth looking up Frank Johnson. Case comes to Frank Johnson, and he takes one look at the pleadings, and he says to the docs, using that great legal vernacular, "You're SOL." Y'all know what that means, right? I don't have to repeat it? Out of luck? Okay. So, he says, look, docs, I can't tell Alabama who to hire and fire. I don't have that authority. But he says, and he reaches in and he grabs jurisdiction of this case. He says, Alabama, you have the most, and the adjectives in the opinion are worth reading, you have the most disgusting, despicable, grotesque hospital in America. And they did. They weren't even cleaning the utensils, and people were getting physically ill in that hospital. So Judge Johnson, because there wasn't a lot of treatment back then, focuses on the physical plant to make life better. Now the principle, the legal principle of the case is fascinating because at that time there was already case law that said if you were incarcerated in jail, you had a constitutional right to adequate health care. No such right had been defined by the courts if you were in a state civil hospital. So what Judge Johnson basically does is he extends that constitutional privilege or right to people in state hospitals and says, if you're in a state hospital and you're in there against your own confinement, you have a constitutional right to adequate health care. And he lists 84 specific conditions that Alabama has to meet. Or, he says, I'm going to shut you down. Now, I'm projecting, because I don't know this for a fact, but I believe so, that Judge Johnson thought if he told Alabama that he was going to shut down the hospital and these folks were going to end up in the street, that they would come up with the money to make the changes. And he was pretty much right. So at one point, Alabama probably had the best state hospital system in America, except they ran out of money, and Judge Johnson was no fool and really tough, and he told them, if you don't do all 84, I'm shutting you down. They got through, I don't know, maybe half of them. They stopped. Judge Johnson orders the facility shut. Well, case gets appealed, basically becomes the seminal case, and states have two choices. You can spend hundreds of millions of dollars in upgrading your state hospital to make it adequate, or you could shut it down and provide community-based care. So what do you think the states decided to do? How many people here think they spent the millions of dollars to upgrade their facilities? Exactly. So they shut them down, and they shut them down hard and fast. But there's a problem. President Kennedy's Community Mental Health Act never got funded. So there was nothing really to absorb this population as they got out. And to make matters worse, we've actually shut down more hospitals in the last 20 years than we had in the previous 30 when this case had come out. And the impact was staggering. In 1955, there were about 560,000 people in state hospitals in the United States. I am not advocating we go back to that. Most of these individuals do not need that kind of confinement. I just want to make a point here. Around the same time, we're estimating, but we believe there were about 5,000 people in jails and prisons in the United States with mental illnesses. Today, there are about 32,000 psychiatric hospital beds in all of the United States. And at the same time, I just want to make a point, if we didn't shut down the hospital system, and again, I'm not recommending we should not have, but if we had not shut it down and our population continued to grow the way it grew over the last 50 years, there would be about 1.5 million people in state hospitals today. Last year, there were 1.5 million people with serious mental illnesses arrested in this country, and 2 million incidents. Almost the exact number of people. But there's another problem. We have about 1.5 million people arrested and 2 million incidents coming into our criminal justice system, and we're using the same competency restoration system that was developed when there were only 5,000 people in jails and prisons with mental illnesses. It's not working. It's just too big, it's too many, and it's inadequate. There's also two terrible, sad ironies to these stories. Number one is we really didn't deinstitutionalize. What we did is we transferred responsibility from these really horrible, crappy state hospitals to these really horrible, crappy jails. And in some ways, for many of these folks, the conditions are worse in the jails than they were when they were in the hospitals. And we've made it really difficult for them to recover because why? Once you end up with a criminal record, it's hard to get housing, it's hard to get employment, you have a much greater chance of continuously cycling through the criminal system your entire adult life. And maybe the sadder, more cruel irony here to the story is that 200 years have now passed and jails have once again become the primary place for people with mental illnesses, just like it was when Dorothea Dix came across those 14 men freezing to death. And again, as I mentioned this morning, our community mental health system was developed for people with moderate mental illnesses. It was never designed for people with the highest acuity and highest levels of psychosis. Our justice system was never intended to serve as the public mental health system, and it is really ill-equipped to do so. And our jails have been forced to house an increasing number of people with mental illnesses who are unable to access critically needed and quality care in the community. And it also created this competency restoration crisis. We spend in the United States billions of dollars, not millions, billions of dollars of trying to restore competency to proceed to trial for a relatively minuscule number of people with mental illnesses. California alone spends $3 billion a year to restore competency for 10,000 people. Now, mind you, their hospital is in Napa Valley, so I'm wondering if they're like feeding them at the French Laundry or something. I don't know how you get to that amount of money, but it is huge. But it is also a lot of money. And I'm going to talk to you about the outcomes in a minute because it is significant, and then we're going to talk about how to fix it. So, also in England, starting in the 14th century, this is about as far back as we can find any record on these issues. The English common law courts declined to proceed against any defendant who was, quote, incompetent to be brought before the court for adjudication. And so they had this kind of formalistic thinking that has since changed, fortunately, but their thinking was rooted in the idea that if you were incompetent to take a plea, you couldn't be charged because you had to either plead guilty or not guilty. You couldn't stand mute, and that's where the term actually comes from, is in the 14th century. And so what they found back then in common law is that the Crown could not proceed against someone who had not entered a plea of guilty or not guilty, and a defendant who stood mute might be doing so either willfully, they called it a mute of malice, or due to deafness or madness, someone that had been or had a visitation by God. So if you've been touched by God, that's what they referred to it as. You had a serious mental illness, and to their credit, they wouldn't prosecute you. There was total bar of prosecution if you had been charged with a crime, if there was an indication. Now, let me tell you the first competency evaluation. It wasn't pretty. They would take you to a small cell and leave you there, and if you didn't speak, then they determined you had been touched by God and they wouldn't prosecute. Or they would starve you, and if you still didn't talk, you had been touched by God and you would not be prosecuted. Or they would take these heavy weights and they put it upon you, and if you didn't scream or yell, then you had a mental illness and no prosecution. And that's how competency began in this world. And so the Crown would not proceed against a, quote, lunatic or idiot whose understanding of the proceedings were so diminished as to prevent a knowing plea. Now, interestingly enough, the incompetency plea survives as an independent bar to adjudication. Now, this evolves in the 1800s through a case out of England called R.V. Pritchard that actually involved a defendant who was deaf and mute. And what the court found is that you needed a three-pronged test. One is you had to be able to take a plea. 2, you had to be able to assist in your own defense. And 3, you had to understand the nature and charges against you. Sounds pretty familiar, right? So that moves into the American law as opposed to common law. And we actually begin to look at this. And the first major case for us is in 1960. Most of you have probably heard of it. It's called Dusky versus the United States, and it is the first standard for competency. And it's a two-pronged test. A, the defendant has to be able to understand the nature and consequences of the charge, and B, they have to assist in their own defense. So this comes out of case law, it gets codified, and it becomes statutory in all of our states. 15 years later, in a case called Dusky versus Drape, the court held, and this is very important because I want to come back to this, because some people think, oh, you have to have evaluations, but no, because listen carefully. The court held that the incompetence doctrine was so fundamental to, quote, an adversarial system of justice that conviction of an incompetent defendant or failure to adhere to procedures designed to assess a defendant's competence when doubt has been raised violates the due process clause of the federal Constitution. So the case law is really, really strong, but it also indicates that it's only constitutionally protected if you're going to be adjudicating the individual. So the essential point is that incompetence bars adjudication, whether by plea or trial, and this includes any pretrial proceeding that may be adverse to the defendant's interest. Again, the problem is we are still using the same system of competency that we used 67 years ago when there were only 5,000 people in the system. Let me talk about Florida for a minute, because some of the principles that have affected Florida affect us all, and it's pretty common. Florida has a decent competency law. It's better than many. Number one is we only have inpatient competency restoration for people charged with felonies in Florida. We do not do misdemeanors. And B, we have a law that says that once an individual is adjudicated incompetent to stand trial, the government, the state, our Department of Children and Families only has 15 days to physically take the person from jail and bring them to a restoration facility. Well, in 2006, when that video you saw was made, we had a crisis. We ran out of competency restoration beds in Florida, and horrible things started to happen. You saw in that video the young man that jumped off the top bunk that broke his neck and became a quadriplegic. He had been in jail for months after he had been adjudicated incompetent. You saw a reference, and it was kind of matter of fact, but the jail director in Hillsborough says, and the guy that poked his eye out, okay? So really horrible things were happening. And what was one of the most fascinating, unusual lawsuits anywhere, the sheriff of Pinellas County, which is over on the west coast of Florida, teamed up with the public defender. How do you like that? They jointly filed a lawsuit against the state of Florida. And the case ended up in front of this very conservative ex-Marine. And he took one look at the case and he said to the state of Florida, it says shall not may. This is not an option. You cannot leave people indefinitely, because we had people waiting 6, 7, 8 months to get to a restoration facility. And he said to the secretary, look, you have two choices. You can start to provide some services in jail while people are waiting, so at least they're not getting hurt, and you need to move them out right away. And if you can't do it and you can't bring me a plan back, I'm going to hold you in criminal contempt of court. She didn't do it. He held her in criminal contempt of court. She was fined $80,000 personally and ordered to comply. As a result of this crisis, because it was, the legislature had an emergency session. They allocated an emergency $16 million plus another $48 million, that's $64 million bucks, to rent 300 beds so they could get rid of the backlog of our competency restoration problem. But they did nothing to fix the problem. And so I ended up getting a call from my Chief Justice down in Miami. I don't know my Chief Justice. I didn't know he knew me. I like to keep it that way. I'm asked to come up to Tallahassee. I'm thinking, what did I do wrong? I go up to Tallahassee, I meet with him, and he says, look, I know you're doing some nice work in Miami on mental health. I want you to fix this. So they remove me from my judicial daily duties, and they assign me to the Supreme Court for 3 years. The legislature gave him a special appropriation to pay for a senior judge to cover my work, and I started working on this project full-time. And it really gave me an amazing opportunity to really understand why this is so messed up. And we did this fascinating study, and what we found was really shocking, and what I'm going to tell you is pretty typical probably of all of us. In 2006, when this crisis occurred, we found that Florida, maybe Florida when you hear this, Florida was spending 30%, 1/3 of its entire adult mental health budget to restore competency for 25 to 3,000 people a year. It's about $250 million a person, while at the same time, we had between 150 and 160,000 people in our state who at the time of their arrest had an acute mental health disorder. But 1/3 of all the money was going to 2,500 to 3,000 people so that we can restore them. Now, we looked further and said, okay, maybe it's worth spending that kind of money if those 2,500, 3,000 people had committed heinous offenses and needed to be behind bars. Guess what we found? For 80%, not 10, not 20, 80% of the people that we spend 1/3 of our money on, 3 things happened to them. They either had the charges dropped, they received credit for time served, or they got probation, and they all walked out the front door of the courthouse without any access to treatment. Some of them getting rearrested before they hit the parking lot because they were still floridly psychotic, but they got through a plea. Because remember, and Dr. Vincent spoke to the judges about this yesterday, competency does not equal treatment. Yes, you get some treatment, but it is very narrowly focused on getting you prepared to understand the nature and consequences of your plea and assist in your own defense, which basically means we get you prepared to take a plea. And the other thing that we found that was startling is that the vast majority of people in prison with serious mental illnesses are only there 2.5 to 4 years because they're not committing serious offenses, but we have a sentencing guideline process, and because they accumulate points on a bunch of low-level offenses, that when they end up picking a third-degree felony up at some point, which is our lowest level felony, they end up with a light prison sentence. And so what competency restoration has also become is a pathway into the prison system for the least serious offenders, who then get out, again without any treatment, and often come back. Now, we've gotten better because some of the reforms that we made in 2006, but it's still not great. Now we spend 22% instead of 30% on our budget, and only 70% of the people that we restore either have charges dropped, receive credit time served, or probation, but 70% are still walking out the front door without any access to treatment. And I just found out that the backlog right now is about as bad as it was in 2006. And so I'm sure we're going to get ready to see a bunch of more lawsuits filed, just like it's happened to everybody else. There is so much going on in the federal courts right now where states are being successfully sued because they are leaving people in jail indefinitely to get assessed, evaluated, and restored. And it has been determined that it is unconstitutional. Let me talk to you about the prison pipeline, though. The fastest growing subpopulation in Florida, and this is pretty consistent around the United States, are people with mental illnesses. Most states over the last 5-6 years have actually seen a stabilization of prison inmates. Leveled out, we peaked, but not for people with serious mental illnesses. Over a 15-year period in Florida, The overall inmate population grew by 56%. In contrast, during the exact same period of time, the number of inmates receiving ongoing mental health treatment increased by 153%, and those experiencing moderate or severe mental illness increased by 170%. It is growing so fast in the state of Florida and in most prisons. When I say it, people with mental illnesses going into the prison system. It's growing so fast right now that if we don't do something immediately to curb this growth, Florida is going to have to build 10 new prisons over the next 10 years just to house the mental health population. The cost to do that is in the billions of dollars so that they could sit 2.5 to 4 years and get released. There's clearly something wrong with a society that's willing to spend more money to incarcerate than to treat. It's insane. And so you look at Pennsylvania, 258 defendants waiting for a bed on an average of 325 days. One defendant waited 788 days. Click, unconstitutional. Another state, the wait is roughly 200 days, unconstitutional. I just learned last night from Rick Schwarmer with the National Center of State Courts, who's here helping us with all this wonderful stuff. Colorado right now is under a federal lawsuit, and they lost. They're being fined, am I correct, $1 million a month, 35 months so far. $35 million fine, okay, by the federal government, and they still haven't figured out how to fix it. And it's still going on. Utah, state sued over waiting times for competency restoration. But what's worse, and what I find so frustrating, the first reaction to every state that gets sued, which is an absurdity, is they think they can build their way out of the problem. So the first thing they do is they build more beds. And they fill right back up. And they have a continuing waiting list because they're not doing what they need to do. Yes, the seminal case on this right now is out of Washington State. It's called Trueblood v. Washington. Trueblood is actually the name of the public defender. In the state of Washington, the public defender can file civil suits on behalf of their clients, and it goes in the name of the PD, and so it's Trueblood. And the federal judge is the judge that has handled the case. Washington State has only been fined $10 million so far, and they still haven't stopped trying to build their way out of it. The 120 or 50 beds that they did build are already full, and their wait list didn't go down at all. So we can't build our way out of it. Yes, we need to be very mindful of Trueblood, but Trueblood doesn't mean we shouldn't be doing things to slow this down. And yes, there is only a constitutional requirement for competency if the government is pursuing charges. And so if we start to put diversion systems in place, competency is not a legal requirement or constitutional. And what we find is that the courts, well-meaning, often misuse competency anyway because we're frustrated. We want to make sure that the person gets some treatment somehow, and even if we know in our heart of hearts that competency restoration isn't going to treat people, it's better than putting some people on the street because we're worried about public safety and we're worried about their own safety. So we end up misusing the system because it's the only system there. There are about 60,000 competency evaluations each year in the United States. Only 20% lead to a finding of incompetence. These proceedings are costly, and they often lengthen an individual's involvement in the criminal justice system. So let's talk about solutions. The story I told you this morning about the psychiatrist was really an issue about competency. And as a result of his case, we stopped ordering competency evaluations for misdemeanors. Now, we did this with the collaboration and cooperation of all the stakeholders. This was not an activist event where one judge, me, or anyone else decided we were going to ignore the law. We had this 2-day summit that I told you we mapped out a process and we came up with a 2-part approach. But what I didn't tell you this morning is we actually created a written collaborative agreement. And all of the stakeholders in our system came to my courtroom and sign this document. The public defender, the state attorney, the county commission, our equivalent of a sheriff, the police chiefs, the courts, and we all decided that we were going to make a structural change. And we were all going to agree to it, or we weren't going to do it. So everybody's name was on that piece of paper. Now, don't tell them there was no consideration, so it's probably not a legal document, but nonetheless, it has withheld 23 years because it worked. Dade County was spending between $1 and $2 million a year on misdemeanor evaluations alone, forget the felonies, so that we could adjudicate people incompetent and release them back to the street. Insanity, right? So what we decided to do was to just first have people assessed. And if they qualified for our program, we would divert them into treatment. And we had a couple different ways to do it. If they met criteria at time of arrest for civil commitment, within 3 days, they were diverted to a crisis stabilization unit. And because they were on a criminal hold, the 72 hours under the civil law did not apply. And what you'll find is, look, the 72-hour thing, which is wonderful, has nothing to do with treatment or recovery. That was put in by the lawyers, not doctors. And they put it in to make sure there was judicial review so people weren't being held against their will without good cause. Nothing to do with treatment. These are chronic, serious illnesses. You don't get better in 3 days. Most people don't even stay 3 days. They stay 3 minutes. Because if they're not imminently dangerous to self or others, which is a whole nother issue, they get released immediately. They're sick, they're not stupid. And so they don't tell the doctor, yeah, I'm going to go shoot somebody right now. They may say, I'm going to shoot him later, but that's not imminent, so that don't count. Seriously, this is the state of the law. So, they get reset in 2 weeks. Again, they're sick, not stupid. They don't want to be in a hospital, and they don't want to be in jail. So guess what happens? They begin to take their medication. Michelle can account to this because she's gone and visited so many of our clients that we have diverted. And all of our staff are trained in motivational techniques. We know how to talk to people. We know how to listen to people. We know how to be empathetic to people. And we tell them, look, what can we do to help you? We never say what's wrong with you. We say, what can we do to help you? And we say, look, the life you're living can't be great for you. Let us help you. And if you let us help you, we're not going to rebook you. We're going to take you directly from the hospital, directly to the courtroom, and one of our 8 peers are going to be waiting for you. And they're going to have food and clothes and medication, and we will have housing, and we will have transportation. The county gave us a car, so we don't have to put these folks on a bus. Because buses in Dade ain't so great. So we gave them what they needed, and the peers helped them reestablish relationships. I spoke about this a little earlier today. The peers are the secret sauce of our recipe, and Michelle. And they really help. And they let people know that there's hope, that there's opportunity, and we're not there to hurt them. And we build trust. And once the person successfully completes the program, which is the vast majority of our cases, the charges are dropped. And you'll hear this from the prosecutor tomorrow. That's why we don't have to order a psychological evaluation for competency, because the state's not pursuing charges. Now, if at some point, and it could be any point in the process, the person changes their mind and says, I want to go to trial, fine. And if there's an indication they may be incompetent, then we'll order an evaluation at that point. No one's right is taken away from them here. That is always an opportunity for these individuals. I've been doing this 23 years. We have diverted about 7,000 people post-arrest. Not one person, not one, is asked to go to trial. Because this is such a better alternative. And look, if they don't take the program, which a small percentage don't, they go back to jail, we order the evaluation, and it is what it is. This is a voluntary program. And most people take the voluntary because it works. Recidivism, as I mentioned, went from about 75% to 20% for our misdemeanor population. Now, we also set up a couple other programs related to competency. And it's a little counterintuitive, but the misdemeanor cases involving people with mental illnesses are much more difficult than the felony cases. Because in order to commit a felony in most cases, you have to have what we call the mens rea. You have to be able to plan. You have to be able to know what you're doing. So the people that get charged with felonies may have a serious mental illness, but they're not as sick. The individuals in misdemeanor court have been chronically homeless and psychotic for decades. Much more difficult, because what we also know is that for some of these individuals, the longer they go psychotic without treatment, the more permanent brain damage there may be. The gray matter gets destroyed in the brain. This is another reason we need to, in my opinion, reevaluate the civil commitment laws, because it's an organ, just like the heart. What happens? The longer the heart is down, the more permanent damage there is to the organ. And if you're unconscious, we don't rush you to go see a judge to determine if we should open you up and save your life. But if you're having a heart attack of the brain and you are floridly psychotic, you have to bring them to someone like me who couldn't get into medical school to make a medical decision. Brilliant. I'm a little dyslexic, that's why I couldn't get in. But seriously, it doesn't make any sense. And so we end up hurting the person over long term, hurting society long term, and costing billions of dollars without people getting offered access and treatment. So, sort of mentioned it this morning, but I'll articulate a little bit more. In Florida, we have a law, you don't have one in Puerto Rico, that's called Assisted Outpatient Treatment Law. And it is, I think ours is a little too narrow, but what it basically says is if the individual meets a certain legal criteria, the court can order them to take treatment on an outpatient basis. And if they refuse, there's no criminal penalty, there's no contempt, but they can then, as an alternative, be hospitalized. Because they're sick and not stupid, they don't want to be hospitalized any more than they want to go to jail, they start to take their medication. And what we do is we put them on a long-term injectable medication. The first medication that came out lasted a month. The next generation lasted 2 to 3 months, and a brand new medication has just come out that lasts for 6 months. The individual, 2 shots a year. Amazing. This isn't all about medication, but for some of these folks, particularly the very acutely ill, it's extremely important to help get them out of their psychosis. So, this law is a civil law. We were able to get the legislature, when I was working in Tallahassee as the special advisor to the Supreme Court, to extend the jurisdiction of that law to county court. Those are the judges that handle our misdemeanor cases, to give them the authority to use a civil law in a criminal setting. And it's fascinating. We close the courtroom because it's civil, it's not a public hearing anymore. We follow all the civil procedures for that particular hearing, and if the person meets criteria, they go into this program, they get on their medication. It's every judge's favorite calendar. Why? Because within 2 weeks, they come back as different people. I'll never forget, I was covering court not too long ago, and we had 4 individuals that were in court that were already in treatment, doing very well, and they were there just to check in, to status check. And we had a new guy, new patient, new defendant, that a petition had been filed to get him under assisted outpatient treatment. And he was crying hysterically, and he was sitting there, and through his tears, he was telling us that his mother had passed away. It turned out it was like a year or 2 earlier, but in his psychosis, this was really a real serious issue with him. And in the middle of the hearing, one of the client's patients got up, and he walked over to this gentleman and gave him a hug. And I will tell you, a month earlier, he would not even notice the guy was crying. He was just as sick as that man 30 days earlier. And it just shows you that with right treatment, with right access, with right case management, people can recover. And so it has worked very well. It's too small, we need to expand it, but for those that qualify for it, it is a life-saving law. The other thing that we did, and this also came out as one of the reforms in our Supreme Court initiative back in, I think the report came out in 8 or 9, we recommended creating an alternative to competency restoration program. Because remember, we did this analysis. 80% of the people we were restoring were getting released anyway. And so what we suggested to the state is do a pilot program in Miami. We're already set up, we have an infrastructure. Fund it, and we'll show you that there's a better way to do competency. So what we do now in Miami, it's called the Miami-Dade Forensic Alternative Center. I'll make sure you get all the materials so you can send it out to everybody. And the legislature initially was concerned that we were doing what they kept telling me was a net widening. I said, I'm not doing a net widening. I'm not trying to get more people treated. I want to take the exact same people who otherwise would have gone to a competency restoration facility and change where they're going to go. And what we want to do is, instead of focusing on restoring people, why don't we focus on reintegrating people back into the community, because that's where they're going anyway. Duh. All these people were going to be released anyway. So, same exact process. You get assessed, you get evaluated. If you meet criteria for an actual competency inpatient restoration, because we also have outpatient, if you're on a low-level felony offense, nonviolent, you're going to go to this alternative program that's housed at Jackson Memorial Hospital for only $1.7 million. We spend $220-something million. 1.7 is nothing. We have 16 beds. They're full all the time. We've done a lot of studies. We had an amazing study done by the residents at University of Miami Jackson Memorial Hospital. And what they found is that this program is exceptionally successful. The state Senate came and did a study, found the exact same thing, that through this program, it's a third to 50% cheaper. It's a third to 50% quicker, and the outcomes are 100% better. Because why? Once the individual is stable, they don't even have to be restored. We find them housing, we find them case management, we sign them up here. We then put them in our felony diversion program, where the court then monitors them for another year. And if they successfully complete that program, just like any other diversion program, except they have to complete a full year, just like any other felony diversion program, the state drops the charges, and they have no criminal record. And so what we're doing is we're decriminalizing mental illness, and we're getting them on a path of recovery. You can't just put someone in a program that has these chronic illnesses. You have to bring a whole set of resources. As Dr. Vincent spoke about earlier, you need to address the social determinants that are putting them into the criminal system, and that's what we do. Now, when people come into our program, we do 3 assessments. And, you know, this is pretty sophisticated, but it works. It's not a one-shoe-fits-all. We have the person, and this isn't just for MD Fact, this is anybody that comes in our jail diversion program. We do a psychosocial assessment to determine the level and type of mental illness that they have. We use a tool called ORIS. Does anybody know what ORIS is? Really fascinating. It's the Ohio Risk Assessment System. It is a criminogenic risk tool. We use it for 2 reasons. One, it's validated, and it helps us determine what risk the person is, not of violence, but of reoffending. And it's free and in the public domain, and we're cheap. And I don't want to spend money on something I don't need to spend money on. And it's really effective. And it helps us make sure that the person isn't going to be integrated with high-risk persons if they're low risk. And it helps us determine who should come in the program, but not the way you think. We don't exclude the high risk from the program. We exclude the low risk from the program. That's what you need to do. That's what the science tells us to do. Why? Because the data is fascinating. The data tells us for low-risk individuals, even with high-need mental illness, 85% of them are never going to get rearrested again. But if you put them in programs with other higher-risk individuals or moderate-risk people, they don't teach good habits to the high-risk. High-risk teaches bad habits to low-risk, and they become a new criminal. Or the data shows they actually spend more time in jail than they would if they weren't in the program at all. Why? They're not picking up new charges. But they have some of the same issues that most people have accessing the court. They don't live close to a courthouse, they don't have transportation, so they miss a hearing, a warrant gets issued, they get picked up on the warrant, they sit in jail for weeks until the case gets heard, they get their credit time served and leave, and we've ruined them. And they get re-traumatized, because remember what we talked about, Dr. Vincent and I, most of this population has very serious trauma issues. And there's one study out of Kentucky that shows us for a low-risk person, and Travis is going to be here tomorrow, he'll talk about it too probably, 3 to 5 days in jail for a low-risk person raises their risk of recidivism by 50-something%. It's really interesting, okay? So we're actually endangering public safety by doing this wrong, and it's counterintuitive, but remember, these people are sick. Yes, we want to hold them accountable. Yes, we want to get them treated, but sometimes incarcerating many of them is going to lead them to more incarceration later. The third assessment tool we use is the Texas Christian University drug screening tool. Again, another validated tool, and again, it's free. And so we do all three assessments, and our amazing staff develops an individualized plan for the person when they're coming out. And they'll help us determine, maybe they need to be assessed for AOT. Maybe they should be going to the alternative competency restoration program. We will make all those determinations based on proper evaluations and assessments and all the good research and data. So again, 30 to 50% cheaper Miami-Dade Forensic Alternative Center, 30 to 50% quicker, and 100% better outcomes than just sending people to traditional restoration. And it is so much cheaper. So there are two great documents that I'm going to commend you to, and then I'll stop for questions. There was a report done by the Council of State Government's Justice Center. It's called Just and Well, Rethinking How States Approach Competency to Stand Trial. And the other is the Conference of Chief Justices and the Conference of State Court Administrators. The name of the report is Leading Reform, Competence to Stand Trial Systems. And Rick was the author, publisher of that particular report. Those documents should be available to you. If you don't have them, we'll make sure you do. But there's basically 10 strategies in both of those reports that pretty much overlap. One is just starting by convening all of your stakeholders so that you can get everybody in the room to start talking about this stuff and mapping out how you're doing it and looking for ways to clean up the process. The second is to start looking at data and information so you can pinpoint ways to get information. The third is start training professionals working at the intersection of criminal justice and behavioral health. There are not enough of them, and we need more. Fourth is to create a robust system of community-based care and supports so that you can do more diversion and keep people from ever needing competency restoration. 5 is expanding opportunities for diversion at all points in the criminal justice system, including after competency has been raised, like we do in Miami. We send people to the Forensic Alternative Center as opposed to competency. And this is number 6 that I cannot stress enough. Limit the use of the competency to stand trial process. Limit it to people who are charged with the most heinous offenses that need to go to prison. This isn't about not sending anybody to prison. Some people do some really horrible things, and they are really particularly dangerous, and they really cannot be out in the community. But that's a small group. The rest of these individuals can be reintegrated, and competency does nothing to help them recover. Nothing. In fact, for many of them, it just re-traumatizes. You want to promote responsibility and accountability across the system. Number 8, you want to improve efficiency in the competency restoration process, which means you want to have deadlines on how long it takes to do an assessment and make sure people's feet are held to the fire on it. You want to make sure that once someone's adjudicated incompetent, there is a smooth, quick pathway within time prescribed periods so people don't sit unnecessarily. And I will tell you where the backlog often is, the judges, we need to move those cases back on our calendar once the person has been declared competent. They can't stay at the hospital because what you're doing and what we're doing, because we're just as bad, trust me, because our dockets are so full and we don't know what to do with the person once we close out their case anyway. So we're like, oh, let them stay at the hospital. But guess what? It's like a hotel that's full. The next person can't get in. So we have to have an efficient system, get them out so more people can go in. You can't let people just sit, and someone needs to be responsible for that over our entire system. And we want to conduct evaluations and restorations in the community. If you're not doing community restoration, for most of these individuals, you can do it. It's a lot more efficient and a lot cheaper. I'm involved with the American Bar Association. Some states, including my own, are trying to start to do restoration in jail. Bad idea. Doesn't really work very well. The ABA standards discourage it, and it's not something we should be doing. And then 10 is if you are going to do restoration, if it's needed, make sure it's high quality, they're equitable evaluations, and the restoration services are really effective. Because if you want to cry, Google Samantha Bee, Florida Mental Health. So Samantha Bee is a comedian. I don't know if any of you heard of her. She used to be on the Jon Stewart Show, and she did a whole thing on competency restoration in Florida. And what she found that I didn't even know exist is that the great state of Florida was showing these absolutely asinine videos to defendants to teach them restoration. Look at it, you won't believe it. Now, they've since stopped that. It's gotten better, but I am telling you, restoration isn't what you all think. And that's a good video to give you an idea of what the system looks like. And then from leading reform, the report Rick did, A, divert cases from the criminal system, restrict which cases are referred to competency, just like the other report, limit competency restoration, develop alternative evaluation sites, develop alternative restoration sites, revise the protocols like we were talking so it's more efficient, develop and impose rational timeliness, address operational inefficiencies, address training, recruitment, and retention of staff, coordinate and use data, and develop a robust community-based treatment and supports. Now you're saying, hey, we've got no money, how can you tell me this? There's resources. You know, Florida's 49th per capita in the U.S. on mental health funding, worse than Puerto Rico. And before I go any further, I should say to you, and maybe I should say it in Spanish, you're welcome, because my state is so generous that we decided not to take Medicaid expansion. And we are sharing our $52 billion with Puerto Rico that has expanded Medicaid. You have money. There's a lot of federal money out there. The state, the Fed, SAMHSA, is doing a wonderful job developing what are called certified community behavioral health clinics. You have 2 of them in Puerto Rico. They are required to work with your criminal justice system to develop diversion systems. I bet most of you didn't even know that. You have to reach out, you have to develop relationships, you have to get them included, okay? I told you earlier, I think I told you earlier, we're a 23-year overnight success. You don't have to fix this in one day, and it won't take you 23 years. We had no blueprint, none of this had been done before. You now have the research, the science, and the know-how to bring this together, and with your Chief Justice, you have amazing leadership to make this happen. So I thank you all again. I think this is the low-hanging fruit area, competency restoration, that will give Puerto Rico a lot more resources if you limit it, and then you take those resources and use it to expand and build a better community mental health system so you can move upstream like Dr. Vincent was talking about this afternoon and try to keep people from ever coming into our system. Thank you all very much. And I'm more than happy to take questions, and as I said earlier, if you're more comfortable asking in Spanish, please do, and would be happy to answer any questions. Yes, Your Honor.
And who does the assessment?
So, which assessment? The one in
pre-
jail?
The pre-arrest one?
Okay, so pre-arrest, we trained 8,500 officers, and we have taught them how to determine if someone meets criteria for civil commitment. And they have done an amazing job. Look, no offense to the psychiatrists that are here or that were here, you don't have to be a psychiatrist to know someone needs treatment. And in Florida, the police have the authority to file a petition to have someone civilly committed. They're not really doing an assessment, they're just doing a determination if they think there's probable cause. I don't even think it's probable cause, it's actually with the civil standard. Reason, I'm a criminal judge, what's the civil standard? Yes, so if they believe that the person might meet criteria, they can take him to a facility, they have to write out what they believe that is, and then the doctors do the actual evaluation pre-arrest. And if they determine that the person meets criteria, they'll file a petition with the court to have them civilly committed. And so the case never comes in the criminal system, totally stays out. If they get arrested, we changed the screening tool at the jail. Beforehand, and it was a nightmare, we would have the corrections department, correctional officers, do the assessment. And what we found is it was all over the place. They were not even, they were inconsistent. So now, Jackson Health Services, which is Jackson Memorial Hospital, which is a good system, who is responsible for the health care in the jail, they have a professional that does the initial assessment, and they use a modified, what's called short jail screen. And that short jail screen makes a determination if the person might have a serious mental illness. If there's an indication that they might have an illness, they now get segregated to the facility you saw yesterday in that video. That's much better. And they're seen by a doctor within 24 hours, a psychiatrist. And then the psychiatrist does a full assessment to determine if they meet criteria for our diversion program, if it's a misdemeanor, or if they should be segregated in the mental health and what kind of treatment needs that they have. And then that information gets transferred also to our jail diversion program. We have staff that is co-located at the jail, and so if they miss them through the assessment, we find them and we make sure that there's a referral if it's appropriate to our jail diversion program. And then all the stakeholders are notified, the PD, the state attorney, everybody's on the same page. We don't even have a mental health court per se, we have a mental health docket. And so those judges are trained, the case comes in front of those judges, and they help manage the case and the person if they qualify for the program.
Great, thanks.
Sure, all right.
And though it doesn't have anything to do with prosecuting somebody criminally, but in my experience, it's also very common to receive people that you notice are not in the right mind.
Mm-hmm.
And we don't have a process where we could just have somebody assess the situation of that person. But they do come, they do not want legal representation. Sometimes they engage in violent conduct in court.
Mm-hmm.
And then it's very hard to deal with that citizen that is presumed capable.
Right.
So
So
that's one question that we should address sometime.
let me answer that first. And it's a great question. And one of the things I meant to talk about that I think we need to start doing, including we're slowly getting there in Miami. And Rick and I worked on another report with this foundation in Colorado called the Equitas Foundation. And we created new pathways. And so if people come in different systems within the justice system, we should have pathways if they meet certain criteria to move them over to civil, if necessary, and to probate. You don't have to be managed in a criminal mental health court if you have a mental illness and you're not a criminal. We should be able to move those cases and transfer them to a civil docket that has those resources, could have the person assessed and evaluated, make a determination what their needs are, and put out like a civil mental health court and manage them and make sure they're getting what they need. So I think there's a lot of things we can be creative about. There's nothing in the law that prohibits it, all right? And a lot of this can be done through agreement with the parties. But I think what we all need to do is, because look, people just don't show up in the criminal system with mental illness. They're in probate, they're in family, they are in domestic violence, and you find a lot of people in landlord-tenant cases. And that's why they're there, because they are having serious mental health issues. They may be on benefits, so they're paying their rent, but they're so disruptive that a petition has been filed to have them evicted. And then they come to court, and boy, are they angry. The only other angrier people are people in their custody and the kids are getting taken away, right? And so we should be prepared for that. The judges need to be trained how to talk to people with these illnesses, how to identify that they may have a mental illness, and then know what the resources are in your community so you can call somebody, and you can always order them to get assessed. If they're in front of you and you have jurisdiction of the case, and they're acting a certain way where you think it's a problem, and they're not understanding you, you do have the authority then to say, okay, look, and I always try, we met with many of your judges yesterday, and when people are in open court, I always first ask them if they mind if I ask them a personal question. I wouldn't ask you how your breast cancer is in open court. Why am I asking you how your psychosis is in open court? Very personal. There's so much stigma already out there, particularly if you're in a criminal court and you have a bunch of other defendants in the courtroom. They're very vulnerable. They are the first people to get hurt, beat up, or assaulted in jail are people with mental illnesses. So don't make it worse for them. So I ask them, do you mind if I ask you a personal question? And if they say yes or they hesitate, I immediately ask them to come up to the bench where I will have an out-of-court conversation with their lawyers. It's not an ex parte conversation, but it's not in open court. Still on the record, but it's private, and they're much, much more likely to confide in you, talk to you, and work with you. And then the next question I ask them, which I learned from someone with lived experiences, the first thing I ask them at that point is, what can I do to help you? And I know it sounds naive. I know it sounds simple. I am telling you, try it. You will see immediately the person's entire composure change. They're shocked that you're asking, and they're just people, and we have contributed to beating the crap out of them in our system. And so they don't trust us either. So when you ask that little simple phrase, what can I do to help you? Everything changes. And they'll start to trust you, they'll start to work with you. They're sick, they're not crazy. Sometimes they lack insight. So don't try to, this is what we do too, and I used to do this too. We have this great desire to convince them that they're sick. That's not important. What's important is that they take a step. They don't have to admit they're sick to get treated. And you'll never get them to admit it if they don't believe it anyway, because their minds are telling them something entirely different. So don't try. But what can I do to help you? I see that you don't have a permanent place to live. I see that, you're not feeling well. Do you have any medical needs that I can get a doctor to see? And find out what the social service system is. Find out how you get them hooked up on benefits if they qualify. Find out where the Certified Community Behavioral Health Center is. Get a relationship. Make a referral. And they'll start to trust. They'll start to work. And if you can, you develop some peers in your system, and it doesn't have to be peers in the criminal system. You could have a peer in your civil system that rotates courtrooms. And if you have a case, hey, John, I need you to come down to my court. I've got someone I want you to talk to. And that helps too, because then it's not just you trying to force some pressure on. And I'm those little simple techniques often work. Thank you.
First of all, thank you for being here.
Thank you.
And talking to us today. Has any other jurisdiction followed the Miami-Dade model, and how quickly or how long does it take to see a significant change in the system?
So I don't think there's anyone yet that is as comprehensive, but there are courts every day in the U.S. that are starting to replicate. Rick runs tours for the National Center of State Courts to Miami, and he's booked through next year, okay? And we take teams of judges, chief justices come, legislators come, mayors come, county commissioners come, and we walk them through the whole program. I was in Wyoming 2 weeks ago, and they are piloting a diversion program in probably the most conservative part of Wyoming, which probably says a lot. Really into it. The sheriff loves it. The judges love it. It's really starting to work. Chief Justice Fox set it up, and she's very happy with it so far, but it's at the beginning. We have other jurisdictions in Florida. Broward County is finally doing this, which is just north of us, Fort Lauderdale. We've got pockets, Sarasota, Tampa, Jacksonville are all putting systems together right now. And across the country, Rick's had several people several times from Salt Lake City. We had Austin, the mayor and the entire county commission, I don't know the entire, but most of the county commission from Austin came. They're putting a system in place right now. I was just in Vermont last week. Chief Justice Reiber, who is one of the co-chairs of the task force, he's putting together a diversion system. I was in Indiana not too long ago. American Airlines really likes me. They had the governor, the speaker, the Senate president, and the Chief Justice. Chief Justice Rush is one of the co-chairs of the task force as well. She's got them rocking and rolling, and they are setting up diversion systems all across the state. Ohio has been an early leader. They were doing this before it was fashionable. A former Supreme Court Justice, no, not the chief. They'll kill me. Not Zenoff. Oh my gosh, I'm tired. I'll think of it in a minute. She was doing this way before. She's amazing, and there's a lot of diversion systems going on. That's why I think ORIS started their Ohio Risk Assessment System. But there is a playbook, a blueprint to use for this. You know, we didn't have any of those things because no one was really doing what we were trying to do. But now it's caught up, and these assessment tools are great. And you should rely on them because they're all validated, and they really work. And is it perfect? No, but it is so much better. Oh my gosh. We went from 118,000 arrests to 53,000. We have 2.5, 3 million people in Dade County. We have less arrests than most of the middle-sized counties in my state right now. Our police shootings, as I mentioned, almost stopped. I mean, it just really significant improvements all up and down the line. And as I mentioned this morning, you're still going to have 20 to 30% of the people, after you do all this great stuff, that need a higher level of service. But if you're successful, as I know you will be, there'll be resources to move some of those dollars to build higher level of capacity to get people what they really need at that higher level. Just think of it like cancer. You know, if you have stage 4 cancer, you don't go to the dermatologist to get it nipped off, right? You go to MD Anderson or one of the, Sloan in New York, or Miami has a really beautiful couple cancer centers now, and you get a higher level of care. So if you have a higher level of need for a serious mental illness, you need higher capacity, and that's what doesn't exist, and that's the new building we're about to open. Yes, ma'am.
Yes, by any chance, do you know if any of those risk assessment tools have been translated to Spanish?
No, but they'd probably Michelle, do you know if any of those tools are translated in Spanish? Yeah, we do them in Spanish.
Okay.
So, I mean,
Just a matter of translating.
they're not complicated. And so you could have your interpreter's office translate them and use them in Spanish. And I'm sure they're equally valid.
And do public defenders use them also?
We use it, and we share the results. The ORIS actually gives a score. And so we have the score on the file. We keep it private. We don't release it because we try to follow some HIPAA related. Yeah, the lawyers for the defendants absolutely have access to it. Are you with the public defender's office? Yeah. So, and our PDs love it. Now, I will tell you, people are unique. When we first started the program, the public defenders were really gung-ho. I mean, they helped us set this up. It was their suggestion to have the person reset for 2 weeks. They showed us the case law that said they could stay. They loved the diversion program. They were great without ordering competency because remember, when you order competency for your client, they're going to sit in jail longer, and they didn't want it. So the state was pretty reticent at first, the state attorney's office, because that's how life is. Took him a year, and you'll hear from, again, Steve Talpins tomorrow. But once he embraced it and loved it, then the public defender was like, something must be wrong with this if the state attorney now likes it. So we had to do a little hand-holding, and I'm not kidding, I'm not exaggerating, you can ask Michelle. We met with all the stakeholders every month for 10 years. And the only reason we stopped is it got too big. We had 300-400 people that wanted to come to a meeting, and it was unruly. The other thing that we did for 14 years, 12 years, I think 12 years before COVID, we would have this luncheon every year. The first year we had it, there were 50 people. The year right before COVID, we had 500 people. And it would be half a day of training for the community, and then the luncheon would be for us to give a CIT Officer of the Year award, because it's really important to reward our law enforcement for making this cultural shift. And I will tell you, I don't know if you all remember those old ESPN interviews where these big macho athletes would get up and they'd start asking them questions and they'd break down crying. Same thing here. These big macho men and women, police officers, get up to get their award. They start to tell the story because it's usually quite a heroic act for us to give them this award. They come with their police chief, their families are there. And the coolest part is, it's like there's 300 people here, we have 500. You're looking around, I'm up at the stage, and I notice that you have a police officer sitting next to what would have been a defendant, the state attorney and public defender. They're all at the table laughing, and the whole dynamic has changed. And the officer gets up there, and they are so touched and moved because I truly believe that most law enforcement go into this job to help people. I really do. And it's a terrible, hard job. And they get jaded because the system beats them up too. They're not appreciated. Sometimes they do things that they shouldn't be appreciated for, but it's not blanket. They're people. And so I remember this was a while ago, I was at Walgreens. I was picking up a prescription for my son when he was a little baby. And he's 20 now, so it's been a while. And I'm at the pharmacy counter, and you know how they have those big mirrors? And all of a sudden, real loud, booming voice, I hear, "Hey, Judge, hey, Judge." And I'm ignoring it. I don't know who it is. I don't carry a gun. I've put a lot of people in jail at this point, and you never know. So I'm ignoring it, the voice is getting louder. So I'm looking at the mirror, I'm trying to see who's calling me out, and out of the corner of my eye, it is a police officer from City of Miami. So I go over, and I'm saying, "Hey, how you doing?" He goes, "Oh, Judge, I'm so glad I ran into you." And I'm thinking, yeah, me too. And I'm like, "What's going on?" He goes, "Judge, I was going to call Hopsy. That's who trains our police. He goes, I wanted your number. I was going to call you." I'm like, "What's up?" He goes, and this is his language, not mine. He goes, "I used to be one of those kind of cops." "What do you mean?" He goes, "I'd get into use of force. I'd arrest him, got him off the street. But since I was CIT trained, I saved 2 people's lives. Because I have never enjoyed and appreciated being a police officer more than I do now." And for me at that moment, I realized that that's why they do their jobs just like we do our jobs. And they need to see that kind of fulfillment and satisfaction and not just keep arresting and busting heads. Because it's not natural and it hurts for them too. So this helps everybody. And it's not just about fixing competency, it's about restructuring and setting up pre and post arrest diversion, limiting the people that come in, limiting who needs to go to restoration. Have restoration, but keep it for those that probably need to go to prison. And everybody's going to win. There'll be more money, there'll be more services, and start to learn where your resources are, because you have more than I do. I'm not kidding you. When I started in 2000, zero money, zero staff. First 2 years, I basically did this alone. And I got people to volunteer, but that's hard, right? So Jackson Memorial agreed to do our initial CIT classes, but they were doing it free, so it was once every 3-4 months. You know, I needed 8,000 officers trained, and we only do 20, 30 at a time. So I went to the mayor, I got a little money, hired a little staff. We started applying for federal grants. There are a ton of federal grants right now, and you should start getting them now while they're still there. SAMHSA has great money for the certified and for other programs, and the Department of Justice and the Bureau of Justice Assistance have a ton of money, and so does HUD. So you want to start going after those grants. And one of the things that we did, first of all, we never pointed fingers at anybody. This isn't anybody's fault. Figured out what everyone's interest was, right? The Department of Corrections does not want this population in jail. They're too expensive. So I said, okay, I know you don't want them in jail. Would you act as our Department of Transportation? Sure. So they transport everybody for us. It's a lot of money. I don't have to pay for it. They got insurance, everything. It's perfect. And they know how to handle this population. All good. The police, you know, this isn't working for you either. Let's do CIT. We had a grand jury report. That's another thing I didn't mention. In Florida, we can use grand jury reports to look at issues of great public importance. And so after this video that you saw earlier came out, fortuitously, there was a grand jury impaneled to look at issues, and this just came out. And so they took this on as a major issue and did an amazing job. I can send you a copy of the report. And it was an indictment of the police for not doing CIT. And they came along tremendously well after that came out. And news media, I mean, they can really be your friend here. This is not usually a sympathetic population. Michelle Gillen sadly passed away last year, but she gave them a voice and she made them empathetic and sympathetic. And they're not cute babies. And so we needed that, and the media was great. And it just has all fallen into place since then. And get it in writing. Cooperative agreements are a great way to go. You don't need to run to the legislature right away to get legal changes. But the other thing that we did is I got my county to agree that if I got a grant, that they would sustain the grant. And the reason that's important is you get a zillion extra points on your application if you have sustainability. So when the county agreed up front that if we got the grant, they would sustain it, the feds are much more likely to give you the money. And we've been able to show every year how much money we save the county. And so it was a very good investment for them, and it has paid off a million different ways.
I was just getting curious because I'm always worried. I'm in a civil court. I'm always
What
worried.
division? Do you do a general jurisdiction and a lot of stuff?
General jurisdiction, civil court.
So you do everything?
Yes.
Okay, we're so big. There's 150 of us just in Dade, so we're...
Get situations that have a name, you have to resolve.
Right.
But I have a...
Could you hold the mic a little closer?
Okay. I'm preoccupied about elderly people. And we had a case of this elderly guy, and he took many charges, criminal charges. He ended by his own devices, killed in an accident that he did on purpose. He didn't purposefully do it for that reason. But through the process, his son and daughter were not in agreement as to his mental state. One of them wanted to have him evaluated, but the other one didn't. So he went through this process, went through all these legal criminal cases, and I just wonder if in this approach that you have implemented, is there any particular way of dealing with this elderly community?
Yeah, so you raise a couple really interesting points. Number one, nationally, what's happening is the homeless population is becoming geriatric. It's everywhere, and we are not prepared. You need different housing, you need, I mean, a lot of the mental health related issues, maybe dementia, Alzheimer's, not an SMI, it's a senior issue. And we're not equipped. In our program, we only take people with serious mental illnesses. There are other agencies, though, that actually have more resources and more money. Florida's pretty good. If you have either an intellectual disability or dementia, they don't prosecute. We only have restoration if you've been diagnosed with an SMI, because you can't restore an intellectual disability, you can't restore dementia. So they're not even going to prosecute the case. And what we're going to do is we will work with the community providers, nursing home, find out what the person's insurance abilities are, resources, and we're going to help them get services out in the community and keep them out of our criminal system. But if, in this case, he came in criminal, he would automatically be assessed without his permission or the family's permission, and we would have an assessment on him from day one, and that will help us. This is, thank you for reminding me, one of the other things we did early on that has been also very helpful, we changed our arrest affidavits. And so on the arrest affidavit, there's a box. And we didn't want to give people a scarlet letter because they're public documents, but it says PMHD, yes, no, unknown. It stands for possible mental health defendant. And the officers check the box, and they know. And if they hit unknown or yes, it's another indicator at the jail for us to make sure that the person's getting assessed. And then when the judge gets it, I always look, I always circle it right away because I want to know, and you know, my radar has to go off and I have to be looking. And it's going to affect how I look at the person, how I treat the person, how I speak to the person, and what services and what kind of track I'm going to be thinking of to get them what they need. So that's another thing to look at when you're looking at redoing your arrest affidavits, which they probably do every 10 years. But it's been really helpful. And we use initials, so most people have no clue what it is, so it doesn't get used against them, and it's not a problem. Okay, thank you. All right, anything else? All right, y'all been amazing. Thank you so much.
We thank Judge Leifman for his conference, and it has been a long and productive day. Le damos las gracias a todos y a todas por su asistencia, participación. Mañana continuamos a la misma hora, a las 9 de la mañana, y los esperamos. También nos despedimos de los amigos en las redes sociales. Así que a todos y a todas, buenas tardes.